The next segment that we're going to be discussing is the lifespan of a typical employment case. And that starts first with the filing of a charge of discrimination with the Equal Employment Opportunity Commission. The EEOC is the federal agency that's charged with enforcing many of the employment laws. And once a charge is filed, the EEOC will conduct an investigation into the allegations in the charge, and then the EEOC will prompt a response from the company, which is typically in the form of something called a position statement describing the employer's defense. Ideally, it's supposed to happen within 6 months, but oftentimes that doesn't happen, and it can be a year or even 18 months that follows. Fortunately, employment plaintiffs have the right to request a right to sue letter after 180 days. And the right to sue letter is simply an admission, a ticket for you to be able to go to court. So the EEOC is a hoop that must be jumped through, and once you're through it, you can finally proceed to the filing of the lawsuit. Once the EEOC has issued the right to sue letter, the plaintiff has 90 days to file a lawsuit in either state or federal court. And that is done by filing what's called a complaint. A complaint contains factual allegations that support the claim of discrimination, and then also an explanation of what the legal theories are that those facts support. Once that complaint is filed, it will prompt and served, it will prompt the employer, the defendant in the case, to file an answer, which is either admitting, denying, or saying they don't have the information to admit or deny the allegations in the complaint. That's typically done within 30 days, although the employers generally get extensions of up to 60 and 90 days. So by now we've talked about at least 6 months at the EEOC, and then another month to 3 months after the complaint's been filed for the employer to file an answer. Once the answer's been filed, that will kick off what's called the discovery phase. It starts first with written discovery. Written discovery consists of interrogatories and document requests. Interrogatories are written questions that you serve upon the defendant, and the defendant is obligated to provide answers to those interrogatories within a 30-day period. Document requests are similar to subpoenaing documents. The document request will compel the defendant to produce or turn over documents that are relevant to the case. Now, oftentimes, employers will resist turning over documents or information. In fact, it's routinely happens, and so it may be necessary to file what's called a motion to compel. That can delay the discovery process for another 30 to 60 days awaiting a judge's ruling. But once the written discovery is substantially complete, we move on to the second phase of discovery, which is oral discovery. Oral discovery consists of depositions, which often occur in conference rooms like this one. The plaintiff attorney will ask any number of questions challenging the employer's witnesses in the case. And the witness is required to answer those questions, except under very narrow circumstances. Depositions are incredibly important, and for that reason, we spend hours upon hours upon hours preparing for the depositions. It's my opinion that cases are often won or lost in the depositions, and so we don't spare any expense and time or resources to make those as effective as possible. Now, unfortunately, while depositions are highly effective in strengthening a case, they're also the most expensive aspect of employment litigation. A typical deposition will cost about $1,000 to $1,500 a piece, and that money goes to the court reporter. And you can have anywhere to 5 to 10 depositions in a typical employment case, so it requires a substantial investment in the case. Now, once the discovery phase is over, both the written phase and the oral phase, the defendant will have an opportunity to file something called a motion for summary judgment. In a motion for summary judgment, the employer essentially argues to the judge, Judge, even assuming the facts are as they say the plaintiff says they are, we still win as a matter of law. And so it's not necessary to go through the expense and hassle of impaneling a jury because we're going to win anyway. And so, Judge, you can dismiss this case now. I mean, that's an oversimplified version. The time frame for getting a summary judgment ruling from the court varies widely. State courts generally rule on motions for summary judgment much quicker than do federal courts. So in state court, you may only be waiting a month or a month and a half for a motion for summary judgment ruling. In federal court, that can be 3 months or 6 months or 9 months, perhaps due to the different loads that the judges carry. Assuming that the plaintiff or the employee has survived the summary judgment motion, you're going to have a trial. A typical employment law trial lasts between 4 and 7 days. What's nice about trial is that unlike summary judgment, you do get a ruling for the most part right away. Once the jury makes its ruling, both sides, well, the side that lost has the opportunity to file an appeal, which obviously can unfortunately delay the payment of anything that's been won in that case. And it's become fairly common for employers to appeal losses, trial losses in employment cases, and so it can sometimes be expected that the employer will appeal. During the appeal, unfortunately, the plaintiff doesn't recover any of the money that the plaintiff or the jury said was appropriate, but can recover prejudgment interest when the ruling on the Court of Appeals finally occurs.